Just by way of background, the falconry regulations were amended in 2013 to transition the federal falconry program to the state by the due date of January 1st, 2014. With the time constraints that that process ran into, we recognized that there would be some cleanup items that we'd have to address at a subsequent time. So the purpose of the proposed rulemaking before you is to address recommendations that would be considered cleanup type revisions and as such would not require additional environmental review. The department initially met with falconers twice during 2013 and 14. To memorialize those recommendations coming out of those meetings, an initial list of subjects to reconsider was developed. Since then, additional recommendations have been received from department staff administering the falconry program, also the Fish and Wildlife Service, and subsequent discussions with falconers at 2 separate meetings, in addition to the ones that we had previously. From the initial list of suggested revisions from 2014 and 15, approximately 50% were accepted and 50% rejected. From the subsequent suggestions, approximately 43 were accepted and 57% were rejected. Just a note, a complete list of all rejected and accepted comments and suggestions are in the eyesore for you. So the presentation won't cover everything. This table summarizes major comments accepted for inclusions in the regulations. It's just here for reference. And a few of note that we accepted was the change of reporting requirements. So, excuse me, before falconers would have to report to the feds and the state both. So we've changed it so that they only have to report to the state. Includes the let it lay provision, which is that letting a falconry raptor feed on inadvertent take of non-TNE species so that they don't have to be removed from the raptor. Allowing falconers to remove bands and reban their birds under certain circumstances. Allows supervision of raptors by non-licensed falconers while the raptor is outside. Clarify process and dates associated with the drawing for the species that have take limits. This table summarizes comments and suggestions that were rejected by the department. I'm just going to note 3 that you might hear in the public comment period after this that are concerned for falconers. Falconers disagree with the statewide limit on prairie falcons. The analysis in the 2013 final environmental document addressed this, and to our knowledge, we don't have any new information. And if there was new information, it would have to be addressed again in a revision to that environmental document. Falconers will no longer be able to obtain permanent possession of rehab birds. So that was stricken from the regulations. So here, that includes eagles. So the 3511, which is the fully protected statute for birds in Fish and Game Code, doesn't allow for the possession of fully protected species for that purpose, which eagles are a fully protected species. And the other issue is that Title 14, Section 679, the rehab regulations doesn't allow permanent transfer of a rehab bird to a falconer. So the third item would be that falconers disagree with the department's authority to conduct unannounced visits to the facilities. So I know this will probably come up in public comments, so I'll reserve saying more about that until then, but law enforcement will probably want to speak to that issue too. So the department recommendation on the issue is that the commission consider the proposed regulatory package for adoption during this rulemaking process. This is just the notice hearing, so the adoption would be later, at a later time. But if there were, excuse me, if there were topics to be further discussed and considered as part of a new environmental document process, the department recommends future discussions occur through the Wildlife Resource Committee and subsequent rulemaking process initiated as needed at that time.
Great, thank you, Carrie. Really appreciate it. Any questions of Carrie by commissioners? Okay, we have 15 speakers. I think what we ought to do is wait till we hear all the speakers. I know we're going to have a number of topics to discuss, and I think there's some ideas for solutions, and I know law enforcement will be able to be helpful in particularly on a couple of the issues, including inspections. So, Mary, will you call the speakers, please?
Sure. Cynthia Maxwell, Troy Morris, Laura Hazelett, Cynthia Shelton, Jason Holland.
Why don't you hold with those names, and then we'll do more after these folks speak.
One more?
No, one more is fine. Yeah.
Peter Stravengilis.
Come on up, please. Welcome.
Cynthia Maxwell, and I would just like to cede my time if necessary.
Hi, good morning, Commissioners. My name is Troy Morris, Master Falconer, member of the California Hawking Club, and president of the American Falconry Conservancy. We appreciate the opportunity here to clean up some of the regulations that were kind of rushed through in 2013. There are a number of things that really do need to be cleaned up. But there are some things that were new additions that don't seem warranted and reasonable. And I'm not going to get into the specifics of each one. There's a number of them, but I'd just like to say that I think, without exception, the points that most falconers are going to object to are a direct result of the failure to follow the laws and procedures as outlined by the Administrative Procedures Act. The primary tenets of the Act are to provide for the authority, reference, necessity, and clarity of these regulations. One of these regulations violates all of those tenets, and the American Falconry Conservancy has filed a letter of appeal that I think you have, but we don't need to go into that necessarily today. So we just ask that you, when you see the objections come from the falconry community, pay special attention to things that are a result of not following the Administrative Procedures Act. We're a law-abiding bunch. What we do is about the lowest impact sporting activity one can imagine, virtually unchanged for thousands of years. We recognize that what we do is regulated, and we're okay with that, but we would ask that when there's regulation added, that you provide for not only the authority, the reference, but the necessity. And if you provide that necessity, then come to the regulated community and discuss how can we accomplish that task in the least burdensome way possible. We've seen a lot of these things handed down, and we just don't understand where it's coming from or why. Thank you very much.
Good morning, Mr. and Mrs. Commissioners. Thank you for having us here. I am a falconer, a master class. I am the Pacific Director for the American Falconry Conservancy, and I own a falconry-based business.
Can you tell us your name, please?
My name is Laura Hazelett.
Thanks, Laura.
And one of the biggest problems I have, of course, being the warrantless search language in our regulations. It seems to me that that language is there to protect me and to protect you when it comes to dealing with outside of the norm things that come up with falconers. So it protects us both from false accusations to each other. I think it's part of the due process that I'm owed as a citizen of the United States. Whether I choose to go into the field with my hawk or my shotgun, I think that is irrelevant. And I think the lack of that due process is a violation of my constitutional rights. So that's my biggest concern with the regulations going forward. And then on a personal note, for me, the written permission aspect of having to have written permission to hunt on private property seems to have become a boundary that I can't get across when it actually comes to receiving permission to hunt with my falcon. Everyone's like, oh yeah, great, go ahead, until I say, well, would you put that in writing? And then they have concerns as to why. Do I want them to sign off that I'm not going to sue them if I hurt myself on their property, or things like that come into play. And due to those procedures, I have been unable to take and gain permission to hunt with my raptors, and therefore my take with my raptors for the last 3 years has been 0 each year for the last 3 years. And so I want you to consider what having written permission means to the average person going out into the field with their raptor. Thank you very much.
Thank you.
Cynthia Shelton, I'm a falconer. Yep. I am one of a new generation of falconers with no negative experience thus far related to the regulatory or enforcement arms of the falconry discipline. I'm glad that there are protections in place for these predators and feel grateful for the opportunity to be in the company of raptors. Thank you for taking on the daunting work of revising these regulations. But that said, I find the language and content of the unannounced inspections to be threatening in the extreme. It was bad enough that not one but 3 uniformed and armed men showed up at my door on inspection day. My neighbors feared the worst. I had to reassure them that I was not a drug dealer, terrorist, or illegal alien. Fortunately, the officers turned out to be very courteous and professional. But I doubt I would feel that cheerful if I came home to find my privacy violated by an unannounced visit. If you want a short notice visit, I'm fine with that, but I need to be present. Not even my landlord can legally enter unannounced unless it is an urgent emergency, house burning down, gas leak, water line break. Any emergency with the birds is more likely to be caused by an unannounced visit. These birds are fragile and do not tolerate the sudden movements or startling noises of untrained DFW officers. Never mind how distressed my dog would be if strange men broke into my apartment. Such an unannounced visit could cause irreparable harm to my animals, family, and ongoing sense of personal safety and security. The chance that a bird could become injured, lost, or even die because of the actions of officers with no raptor experience is too horrible to contemplate. There is a reason we take licensing tests and apprentice for 2 years to work with these birds. The inspecting officer would have to do the same to fairly assess what he is looking at. And I doubt the DFW has money or manpower for that kind of dedicated training. And I know the officers who came to my door had no Muse inspection training because 2 of the 3 were there with the hope of learning something about it. And the 3rd officer and I ended up developing a PowerPoint training presentation for DFW inspection officers. It has fallen to the falconers to train their own inspectors. Is there something wrong with this picture? To be then threatened by that same officer entering my home against my will, and when I'm not present, even if it never happens, the threat is an affront to my personal well-being and constitutional rights. So what I would like for you to consider is to please include the language that permittees must be present during inspections, because for our own government departments to threaten law-abiding, license-holding, annually reporting, and well-documented people who love birds of prey is not what I understand America to be about. Thank you.
Thank you.
Good morning, Commissioners. My name is Jason Holland. I am a disabled Air Force veteran, and I'm also the founder of a program which introduces disabled veterans as therapy for wounded and disabled veterans. I'm an apprentice falconer. I have not been doing this long. The new regulations, the new proposed regulations, are of particular concern to me in that I am not only a disabled veteran who does deal with post-traumatic stress, but a father, and we do have other animals at my home. The proposal to change the regulation to remove the phrasing "with permittee present" is the reason I'm here today. That is entirely unacceptable. I do completely understand and support the need for unannounced inspections, but to do that and subject my wife and child to an armed law enforcement officer coming to my home asking or demanding entry to check my bird, my records, my facilities, while I'm not there, I can't imagine that any of you would want that same situation to happen in your home when you're not there, whether it's something you're passionate about. If any of you were falconers, I doubt you would be so quick to think that, sure, come in, take a look at my bird and all of my stuff while I'm gone. It's not an equitable or righteous way to enforce the regulations. And thank you all for your time, and that's all I've got.
Thank you. Thank you for your service.
Good day. Peter Stavrianidakis. I'm from Hillmar, California, right in the Central Valley here. Been a falconer since '81. And I also am an attorney with the Public Defender's Office in my county for the last 15 years. The issue that I had when I first started falconry was read a piece of paper that gave up my rights to do something I love, gave up the right to be secure in my home, to do something I love. And I was assured by my sponsor, by California Hawking Club, I'm a lifetime member, who also said, this doesn't happen, it doesn't happen often. They usually have a good reason to come by, and the visits are typically very cordial. They do their inspections and they go home. And if everything is fine, then everything is fine. It's like saying, search me whenever you want, it's okay because I'm doing nothing wrong. The issue is this. Pick the sport you love, an activity you love. And then to do that activity, you have to give up your right to be secure in your own home to do it. Now, as an attorney, I've drafted many 1538.5 motions. There's suppression motions for illegal entry by officers, illegal detentions, gathering information from people that was illegally obtained. There is not a court in this state, on a state level, that would uphold a person, warden or otherwise, coming into someone's home without permission, without probable cause, without a warrant. Yet this regulation, which is unconstitutional, does provide for that very self-same entry. This cannot be. Now what's happened is California has, because they were told to adopt a regulatory scheme that was set up by the feds. And if you adopt ours, then you can do this and take care of it on your own, and we'll be outside of the scope of the day-to-day management of falconry regulations in California. But to adopt a regulation in California, it has to pass at least the muster of constitutionality. And I implore you today, before you make any decisions on the issue of inspections, is that you seek independent counsel. I'm not saying go to an attorney that works for Fish and Game or Fish and Wildlife, but go to any attorney and say, I'd like to practice falconry. Here's a requirement. Is that constitutional? No one will say that that holds muster. So when we have to adopt regulations as Californians, we have to adopt regulations that, one, are not violative of the United States Constitution, and two, not violative of our own state's Constitution. There's no, is that my time?
Go ahead and finish up.
If that is the process, then this portion of the regulation must be stricken, because you can't do it. And if you do, and it comes into a court of law in a criminal courtroom, the information gathered will inevitably be thrown out and will open itself up to appellate issues, maybe Supreme Court issues, to get the final resolution. My experience thus far is that it never gets that far, because once a case is dismissed in a lower court, haven't had anyone come back up and challenge that judge's decision on its rulings on suppression motions. The cost is prohibitive. I certainly do not want to be the poster child for the person that says, no, you can't come into my house today. I don't want to subject my wife, my family to it. The financial burden and expense, even as an attorney, it still costs money.
Okay. I'm going to ask you to wrap up, but we appreciate we're going to talk about this a lot, and we'll certainly talk about it. We may have questions for you later in the process.
I appreciate the time you gave me, and please take that one bit home with you. Seek independent research on that one issue. Thank you.
Mary, we call the next group of speakers, please.
Bill Gaines, Jennifer Hosterman, Noel Amherd, Bill Ferrier, Kate Marden, Adam Chavez, Martin Bender, Peter Martin, and Glenn Stewart.
Thanks, Mary. Please come on up, somebody.
Good morning, commissioners and staff. My name is Jennifer Hosterman, and I am a Master Falconer. I also serve as a board member for the California Hawking Club. I have a female Harris hawk, and she hunts rabbits, and she lets me tag along. So I'm a former mayor, and with 10 years of public service, I understand where you're sitting and what you have to do in order to really go through all of the policy and discussion and hearing from the public in order to keep really the entire state of California a healthy place for all of us. And so thank you for your service. We come to you in a tone of conciliation, but we're also, quite frankly, we're mad as hell. For all the reasons that you've heard before me and the reasons you'll hear after me, there is a lot of confusion, misunderstanding, inconsistency, which leads to an onerous set of regulations. For that reason, I'm going to again urge you, I know you've been urged before, to simply go back and adopt the federal falconry regulations. And there are reasons for that. Now, I know that when we've asked you to relook at that in the past, you have replied that that would be onerous because of having to go through the CEQA process, the Administrative Procedure Act, Office of Administrative Law, to determine every single rule as far as its necessity, authority, clarity, consistency, reference, and non-duplication. Well, I would say that you have to do that no matter what you do. And I would also say that relying upon the federal regulations is far more defensible. And I would cite to you Dr. George Allen's work. And Dr. George Allen served as chief of permitting for the U.S. Fish and Wildlife. And in all of his years, he spent roughly 13 years rewriting the falconry regulations. And he went across the country, again, 13 years interviewing state agencies, falconers, taking evidence, gathering information in order to write a set of regulations that could be applied from state to state across the entire country. They're not perfect, but they're understandable, they're implementable. There is some consistency. We would still want to work with you in the future to make some changes. So with that, I want to say thank you very much. Again, I think the federal regs are far more defensible than the preferred alternative, and we would urge you to look in that direction. So thank you very much.
Thank you.
Good morning, Commission. My name is Noel Amherd, also a licensed falconer here, and a current board member of the California Hawking Club. I humbly hold that the conviction that this 5,000-plus-year-old tradition models an ethical and philosophically balanced relationship between humans, land, and animals, even recognized by the United Nations as an intangible treasure of humanity in 2010. So in this light, I'd like to take a brief moment to discuss issues of fees and some regulation inconsistencies, and again, arguing in favor of adoption of the federal falconry regulations. All hunters pay license fees to pursue their sports in California. Pig hunters, roughly $69, deer hunter, $78, duck hunters, $82, bear hunters, $92. A falconry duck hunter pays $178.84, more than twice as much as a shotgunning duck hunter. A 14-year-old just starting out in falconry will pay fees for his or her examination, facilities inspections, for a total first-year cost of $379. We have the highest cost in fees and the lowest impact on game species of any hunting group. So we pay our way. Today, my colleagues and I are asking the state to adopt the federal regulations as much as possible under state law, and we'll describe several areas in detail where there are particular problems. But before we do that, I want to just list 5 short examples where state language is either confusing or inconsistent with federal requirements. 1, the state asks us to, quote, to carry, quote, any document required for the falconry activity in which the licensee is engaged, unquote, creating uncertainty for both falconers and law enforcement officials. A hunting license and a falconry license suffice. 2, the state regulations say that a falconer must ensure that threatened or endangered species are not taken. Well, we're doing our best, but we're not in direct control of these natural birds as hunters are in directions of their bullets. But we're happy to report missteps by our birds. 3, in sections describing possession of raptors, the regulations contain one long, confusing statement that seems to contradict possession of captive-produced, fully protected birds. 4, proof of legal acquisition is a redundant requirement because it is elsewhere stated that falconers must report disposition of raptors electronically. And 5, assisting rehabilitators contains contradictory language. It simultaneously states that no transfer to falconer occurs when a falconer cares for a rehab bird, but also that that transfer must be reported electronically. So we respectfully request the Commission to use the federal language as a basis for new state falconry regulations in California. Thank you for your consideration and your time.
Thank you.
Good morning, Commission members and guests. I'm Dr. Bill Ferrier, California Hawking Club Director, a UC Davis veterinarian. I've been a falconer for nearly 50 years, served on the School of Veterinary Medicine as a director for the California Raptor Center for over 10 years. I had the pleasure of meeting with the U.S. Fish and Wildlife Service in Washington, D.C. as part of a team from the North American Falconry Association when the federal falconry regulations were being drafted. I appreciate the work that the California Fish and Wildlife has done with the California regulations, but there remains discrepancies which really need to be addressed. Simply stated, California should just adopt the federal falconry language. One example of a discrepancy is the permit requirement for out-of-state falconers visiting California with their birds. The current regulation states in part, the Department's License and Revenue Branch shall be notified within 10 days prior to the importing the raptor. A non-resident or non-U.S. citizen shall submit to the Department's License and Revenue Branch official written authority to export the raptor from the originating state, along with a health certificate for the raptor prior to importing the bird. All that should be needed is a falconry license. After numerous phone calls and several emails to Fish and Wildlife, I could not get clarification on this requirement. Finally, I received an email from Gina De La Rosa saying, sorry for the delay in getting back to you. Per our analyst, she clarified the only documentation to import a raptor is to have a health certificate and a current falconry license. The Department's practice is completely different than what your written regulation is. When we drafted the federal regulations, we recognized that health certificates are a function of the USDA and APHIS, not the U.S. Fish and Wildlife Service, and not the California Department of Fish and Wildlife. Visiting falconers who will be buying hunting licenses and other services in California should only be required to possess a falconry license, which is a standard written into the federal language. There is no reason, other than increased bureaucracy, to require an import-export permit for falconry raptors. Each raptor is registered with state and federal databases. It is no longer necessary to cover these birds with permits as they move about the nation. Databases are immediately accessible to wardens in the field. Frankly, California just needs to adopt the federal falconry language. Thank you very much.
All right, how's that? Good morning. My name is Kate Martin. I am a master falconer and an educator. I have a business called West Coast Falconry. I've been in business for 10 years. Primarily, I do falconry education, but I also am an abatement falconer. And the item that I'd like to speak about today is the suspension and revocation laws that say that if we can have our license suspended or revoked after just one violation. I feel that this is not really, it's unfair because it doesn't follow the pattern of other hunters. Suspension or revocation of our license after just one violation it doesn't really make sense when all other hunters can have 3 violations over a 5-year period without being suspect to suspension or revocation. For example, it's against the law to hunt from a vehicle. Is it right, logical, or fair that if you fly your bird from a vehicle, you will lose that bird even if it's a captive bred bird and non-native, and you will have your license possibly revoked if not suspended? But if you shoot a gun from a car while you're hunting, you merely get a strike. It just makes no sense. The department's justification is that we are in the possession of living raptors, and it's true that we need to be careful of our birds, and we prize them, and we don't want to make a mistake. But it doesn't seem right that a hunter can make a mistake with a shotgun or a .30-06 3 times. Things die when you make a mistake with a gun. They don't really die when you make people don't die when you make a mistake with a hawk. How can it be okay to have 3 gun violations but only 1 with a bird of prey? Please give us the same chance as the other hunters. Don't make the suspension an automatic response to just 1 violation. I appreciate your time and your consideration in all these matters. Thank you.
Thank you.
Good morning, Commissioners. My name is Adam Chavez. I've been a falconer for over 40 years. My initial sponsor actually was a game warden who headed up the falconry program in the state of Nevada. I'm the current vice president of the California Hawking Club. I'm also the South Pacific director for NAFA, and I'm also an owner of an abatement firm, and I'm the author of NAFA's comments on the recent federal abatement laws. I've also offered additional training for 13 wardens regarding falconry in Southern California, and we're progressing with that. Today I'd like to discuss the prairie falcon lottery. The prairie falcon is the only large falcon currently available in California. These new falconry regulations have limited the prairie falcon take to 14 birds a year based on very little data. In fact, I cannot find any good peer-reviewed studies that don't draw the bulk of their documentation in California from studies done in the 70s. That was the best study, the most, has the most information. Also, if you look at the analysis in the final environmental document, it was based on best available population trend data that wasn't even collected from the nesting territories. So it's not that accurate, and there's no sound biological evidence to support this added restriction on the prairie falcon take. The falconry take that has been in existence for a number of years has not shown any negative impact on the prairie falcon population, so I don't understand why we would want to change something that has shown no impact. The prairie falcon is a resident of vast arid and unpopulated regions of the state, and as such, information on the species is scarce and dated. Most of what we know about the bird's populations derived from a consensus conducted and published in the early 70s when the eggshell thinning effects of DDT were at its peak and known to be crippling reproduction of other raptor species, including the peregrine bald eagle, as well as the osprey. This comprehensive report found an inordinately high frequency of non-productive pairs during those years of DDT contamination when 50% of the territories were occupied and only 50% of those were productive. Peregrines, bald eagles, ospreys are all known to have recovered from the effects of DDT, and we expect the same results from the prairie falcons. The environmental document cites various estimates of the California prairie falcon population. The data from Partners in Flight, 2,900 breeding individuals of 1,450 pairs. The California National Diversity Database contains 456 records of California prairie falcon nesting territories, which comes from the comprehensive 1986 report, which is summarized from the data in the 70s. Lastly, I would like to recommend that the lottery be changed on the timing. Currently, any raptor biologist can tell you if the birds hatch May 1st, then if you're going to issue permits, they need to be done in March so that you can actually acquire a nestling that year. Otherwise, you're limiting the take to passage prairie falcons. And I guess my time is up.
Great. Thank you very much.
Thanks.
Good morning. My name is Martin Benatar. I'm with the California Hawking Club, and I am a current board of director. I've been on the board of directors for 10 years. I'm a master falconer. The CHC has been working with the Fish and Wildlife Department since the adoption of the federal regulations. We have been trying to clear up the issues with the language and interpretation of the current falconry regulations that have been adopted. It seems that the farther we go into this process, the worse these regs read. And I'll give you one example that needs to be addressed and changed. In the current falconry regulations 670H3, possession of raptors from rehabilitation facilities. In this section, it states that a rehab facility may permanently transfer to a falconer a non-releasable raptor as long as the raptor being transferred is appropriate for that level of falconry permit. In the last meeting the CHC had with the DFW, we were handed a revised copy of the regs that the department wants to adopt. In the regs, they completely removed the section that covers the transfer from rehab to falconry. The reasoning was, we are not allowed to do this under 679 F4 of the rehabilitation regulations. In that section it states, if any animal cannot be released, it shall be transferred to a zoological garden, museum, college, university, or other educational or research institution or wildlife exhibitor. Falconers need to be added to this list. In some cases, this is an example, in some cases there are raptors that cannot be flown, hunted, but are not suitable for release to the wild. And these raptors are turned in after they've been irreversibly tamed down. We call those imprints. They're imprinted to human beings. What's better, a life of incarceration on display or a bird of prey in the hands of a falconer hunting, pursuing game as close to wild as possible? So we've been working with wildlife rehabilitators for decades, flying raptors, conditioning them, hunting them, and for release back to the wild. This is a relationship that shouldn't be severed. The California Hawking Club is requesting that the Commission adopt the existing federal falconry regulations and amend them for California law. Thank you.
Can you, what was that provision again that you just cited?
The section number?
Yeah, the section number for that you wish to be added to be able to take possession of.
The section number was 679F4. If any animal cannot be released, it shall be transferred to a zoological garden, museum, college, university, or other educational research institution or wildlife exhibitor.
I'm going to address this now because I know where you're going with this.
Yep.
Here's the thing: that section isn't. It's a code section, not part of these regulations.
Right.
And so, while I think we'll discuss this, but I think there might be some willingness to address that. That can't be changed today. That would have to be through a petition to change that part of the code. So it's actually, it's fine to bring it up today, but we'll talk about when we get a little bit later how you address that in the future.
Okay. All right, thank you.
But I would just mention, I think it's a valid point, and I think it's worth consideration.
Thank you.
Good morning. My name is Peter Martin. I'm a general falconer and a new member of the board of the California Hawking Club. I'm a criminal investigator with the Yolo County District Attorney's Office. I've been a sworn peace officer in the state of California for over 38 years. During my time as a peace officer, I had the privilege of working for about 3 years as a motor officer. I'm very well aware of the reaction that people have when I put the red light on them and pull them over. They were worried about this because there was a chance I might write them a ticket, and that ticket would cost them money and time. When a game warden contacts a falconer, the falconer knows that one violation can end his or her career as a falconer. This is why we come to you today and ask that for a fair and reasonable department guidelines to be enacted when the department officers visit our homes to ensure that the falconry raptors we're keeping are being kept in accordance with the law. We have no problem with that at all. We don't object to surprise inspections. We understand that the privilege of keeping a migratory bird Treaty Act protected bird is accompanied by performance requirements, and we're happy to meet those requirements. But the requirements of inspections is a good example of how state language has unnecessarily strayed from the federal requirements and has become unfair to falconers. I'll give you just a quick example of a federal regulation that says that falconers must submit to their state a signed and dated statement showing that they agree to the falconry facilities and raptors may be inspected without advance notice at any reasonable time of the day, but the falconer must be present. The same provision under state proposed regulation says that the department may conduct unannounced visits to inspect facilities, equipment, or raptors possessed by the licensee, and may enter the premises of any licensed falconer during a reasonable time of day and on any day of the week. These are small but important differences. The state language authorizes officers to enter our homes, our premises. The federal language does not provide for that. Why would an officer checking on the status of our facilities and our hawks need to enter our homes? The federal language also emphasized that the falconer must be present, while the state language does not.
Your time is up.
Go
ahead and finish up, please.
Thank you. We don't object to surprise visits to keep everyone honest. We do, however, object to officers coming into our homes and disturbing our birds when we aren't present. Today, we ask the Commission to direct the Department to adopt the federal language that was laboriously prepared over decades of time with coordination between falconers and state officials. Thank you for your time and consideration.
Thank you.
My name is Glenn Stewart. I'm director of the Predatory Bird Research Group at UC Santa Cruz. We're the organization that worked closely with the department. At a time when the peregrine falcon was critically endangered, we could only find 2 pairs of peregrines in the state in 1970. Today, I'm happy to report that they've been removed from the state list of endangered species. There are more than 300 pairs, we estimate, in the state today. I'd like to just draw your attention briefly to Code Section 3511. It's mentioned in the falconry regulations. I know it's not something that you can change, but you can support or oppose it when it comes before the legislature. We do want to at least amend 3511 or hopefully repeal it. It's old law. It was passed in 1967. The legislature was trying to do the right thing. They protected 13 birds, like the peregrine falcon, that were in critical danger of extinction. They subsequently, we passed the California Endangered Species Act, which takes care of that job for us in the state. Peregrine falcon was vetted through a 2-year process by the department, decided that it should come off the California list of endangered species. It's still fully protected. Situation today is we have peregrine falcons that they eat birds that they catch in the air, I might say. There are other birds that haven't recovered from endangered status, like the California least tern. When peregrines and least terns are found in the same vicinity, peregrine falcons are trapped, they're driven a long distance away, and they're released. If they have babies, the babies are captured and taken to a rehabilitation facility. But falconers cannot have these birds. They can be managed, they can be trapped. In some cases, they're killed by wildlife managers, but we can't have them. Apparently, we need to change 3511 to make that happen. Probably more important for us to look at today is the process of reviewing these regulation changes. I honestly didn't know that we couldn't talk about substantive issues. We keep coming to the department and we say, these are our issues. And for example, on March, we came to the department. We were responding to a draft of the new regulations. We responded in writing. We sat down with the department to review our issues. And the first thing that happened was we pulled them out and we said, okay, we're not going to discuss this issue. We're not going to discuss this issue. We're not going to discuss issues. And it went down, and 3/4 of our issues, we couldn't even talk about them. We need a better process. We appreciate that the Commission directed us to work with the Department in 2013. We'd like to continue that. The regulations, in our view, are still broken. And so here's my suggestion. Send somebody from Commission staff to sit with us, somebody who can say yes, no, or why when we sit down with the Department to review these things. Because frankly, we're going backwards instead of forwards. Thank you very much.
Thanks, Glenn.
Can I just say for the record that something done or adopted in 1967, we would prefer to refer to that as mature, not old.
I'm glad that's in the record.
Yeah, thank you.
Hey, Bill.
President Sklar, commissioners, my name is Bill Gaines. I'm here today representing the California Hockey Club and other Falconers here in our state. First of all, I'd like to welcome our two new commissioners, Commissioners Burns and Silva. Welcome to the dais, and also our new executive director, Ms. Termini. Welcome. It's been a pleasure to work with Valerie thus far, and we look forward to working with her for many, many years. Falconry is easily the most heavily regulated, the most specialized, and the most intricate type of hunting out there, period. A few years ago, as you heard earlier, the federal government decided, in order to work on what they considered more important things, passing the federal regulations down to the state to oversee the falconry. You heard Dr. George Allen's name earlier. Dr. George Allen, who is now retired, ran the federal falconry program for the U.S. Fish and Wildlife Service for quite some time, arguably the most noted expert in falconry that I'm aware of anyway. Let me read a couple of excerpts from a letter that he recently wrote. Dr. George Allen said, "In general, falconry is considered by many to have no impact on wild raptor populations. Current federal regulations are the result of years of extensive input from both falconers and the states, and I'm not sure why any state would feel the need to be more restrictive than the federal regs except for take of species of special concern." That is the words of the nation's arguably most expert falconer. Most of the states, when they had the opportunity to adopt the federal regs a few years back, took that opportunity, adopted the federal regs, and simply tweaked them to make them fit their state. California chose not to. Problem is, California Department of Fish and Wildlife does not have experts on this very intricate sport on staff. I will give Carrie and her staff credit. They met with us several times trying to get this right. We got a lot of it right, but frankly, the package that's being brought forward to you for possible authorization of notice today is riveted with problems. You heard about a few of them today, most notably the unwarranted inspections. Big problems with that. What we're asking the commission to do, and this is something that we believe you may be able to fix today, to simply direct the department to adopt the federal language. You heard Pete earlier mention the differences between the two. Going back to the federal language would alleviate all our concerns in the inspection process. You also heard about the one violation. I've got the pleasure of working with a variety of different hunting groups for big game, upland game, waterfowl, and so forth. Nowhere am I aware of where one violation caused revocation or suspension of your license. That is simply unreasonable. That needs to be changed, and I believe that's something that the commission can do today. If the commission is not willing to direct the department to go back to the federal package and start over, which frankly I think would be quicker and easier for department staff, we do ask that you delay authorizing notice today, kick it back to the August meeting, and give us a couple of months to sit down with the department to try to work out those problems that cannot be addressed today. Commissioners, we are under no timeline on this. There's no hunting season that's going to start here in a few weeks or in a few months that we need to wrap up these regulations today in order to get those regulations in print. We've got baseline regulations in place. There will be a falconry season this year. We're under no timeline to rush this decision. Delay notice, give us a couple of months, fix what you can today, and allow us to work with the department over the next couple of months to bring back a more reasonable package at the August meeting. Thank you very much.
Great. Thank you. Thank you, everyone, for your comments. I'm sure we have lots of discussion and questions. I want to try to break this down into a couple pieces, and I want to make a couple comments first. First of all, there's a couple things that we can't do today or in August, and I think we ought to dispense with those quickly on two issues. The issue of rehab birds, as I said already, and I think Commissioner Williams is going towards, that requires the best way to pursue it is a petition to the Commission to address those regs. I think it would be strange to me that falconers aren't included in people who can take rehabilitated birds. That's just a logical thing, and unless any commissioners object, I think you can take comfort in that you'll be received well if you submit that petition. The second thing is 3511, which is unfully protected. Again, that's not something we can do. Again, I think you might want to ask the WRC to look at it, to talk about it, and recommend whether or not the Commission should request the legislature to address that, because it's an inconsistency that's existed for a while and ought to be cleaned up. It's a cleanup measure. I don't think it's a controversial one in the end, but again, it's not something we can do. I want to talk about just one issue first, if my fellow commissioners would humor me on that, and then I would prefer to have them talk about the other issues before I do, but it's on inspections. I'm a deep believer in the Constitution and in the Fourth Amendment as it applies here. Unreasonable search and seizure, have I got the right, got my count, you know, but there's a balancing act. It's an incredibly important part of our Constitution. It's reason it's up near the top, and I'm uncomfortable with the regulation as written. And I'd like to make a couple suggestions of changes that I think would improve it. The first is to change in J3A, change the word premises to facility. I think the purpose here is to inspect where the falcons are, not to give access to your house, your garage, if there aren't falcons there. Now, be aware that facilities are where the falcons are. So if you keep a falcon in your house, you're creating greater access to your home. To what the very articulate counsel said earlier about giving permission, you're getting a special right to keep a wild animal on your property. And to do that, the state asks you to give up certain rights. As you do when you get a driver's license, you give up certain of the Fourth Amendment's hardest and clearest protections, not all, but you give up some. You have to give up some here for the inspections. Changing it to facility, I think, is a significant difference, so it's only inspecting where the falcons are on your property where you choose to keep them. The second thing is, before the last sentence in that section, I would recommend inserting the following language, and our counselor has it in electronically so we can make sure we get it exactly right, but I want to read it. If the department arrives for the unannounced visit and the licensee is not present, the department shall make reasonable effort to contact the licensee using the contact information provided by the licensee so that the licensee has the opportunity to be present during inspection. I know that's not everything you want. It's closer to the federal regs, and the problem is not probably any of you here. It's the few percent of falconeers who are actually the problem, and if the requirement is that they must be present, they will use that to avoid an inspection entirely. So again, it's a balancing act to make sure that we protect these birds and we have the ability for proper inspections, but for the vast majority of falconeers who are obeying the law and really take care of these birds well, they have a greater level of protection. It's a compromise that gets us a lot closer to what you're hoping for. It may not be exact, but those are my suggestions to help on the inspection issues. And with that, I welcome fellow commissioners before I talk about any other issues.
Just one other issue that came up quite a bit was this issue of the using the federal regulations. I'd like to get more information on that from staff also. I'm not clear on why we can't do it or what the differences are. And
terrific. Let's address that now then. That'd be terrific. Can Safford and Carrie, can you talk a little bit about why we didn't adopt the federal regulations?
Sure. So when this process started some time ago, so first of all, the state regulations can be more restrictive than federal regulations, just not more liberal. So we had, with George Allen, who was mentioned before, I worked closely with George Allen through this process. So he reviewed several drafts of the initial drafts in 2013 or 12 when this came before the commission. So he reviewed those drafts and said, they meet federal regulations because we weren't more liberal. That said, many of the things that had come up where falconers really wanted the federal regulations just adopted is the possession of species. So the federal regulations allow most species, raptor species, to be taken. So at a state level, we have to consider the population at a state level, not at a national level, as the feds do. and so that was part of the environmental document, is looking at population levels of all raptors that would be used for falconry. And for instance, we took ferruginous hawk off the list because of concerns for population numbers there. Plus, they don't breed in California that much. So as an example of one change that we did, or we added barred owl. So there were some changes that we did that were specific to populations in California that were different than federal regulations. So, and some of the other changes that may have been different were probably some stuff that was in our regulations prior to the feds, our previous regulations prior to the January 1, 2014 deadline. So like the private property permission and such like that. So. And I don't want, it would be hard for me to recollect every single thing. The regulations, the federal regulations are quite complicated as well. I think they're just as long as ours. So it's not that they're simple by any means. So it would take us sitting down to the table and comparing side by side what those changes may be that they are concerned of, other than that I know that the species issues, they allow most take of any wild raptor, which we're more limiting.
Commissioner Burns?
Yes, in light of my very short tender, I do have a question. You know, America's brought up some possible changes to the regulation. If this, and for the stakeholders that weren't present yesterday, I was appointed to the WRC commission, or committee, excuse me, yesterday. So my question would be, if the regulation is passed as amended, or proposed amendments, and these issues come to the WRC upon action today from the commission, maybe you could explain to myself and the stakeholders what that process would entail as far as meeting with the WRC, timeline of proposed changes to the regulation on a go-forward basis. So I guess the thumbnail it, how expedited could some of these issues be that aren't amended today?
Right, so let me just clarify. So if we pass it as is with a few amendments today, how quickly could folks come back and discuss possible changes?
Correct, and how often would that be brought back to the commission for the change?
I'll take a stab at this in part, and that is that it could be on the next WRC agenda. There's no reason we can't add that. Those discussions could happen quite quickly. Depending on the change and whether it requires environmental review, it could be done faster or slower depending on that. Some things could be done very quickly and very easily if it's determined that environmental review is not necessary, or the simplest form of environmental review can be done. There might be other things that require longer review, particularly around a specific species. Those will all take longer. Is there anything that I didn't get right on that? And I want to also say something. There's some insinuation that the experts didn't work on this. I understand that falconeers have a really deep knowledge of their birds and the birds in general, but to say that we didn't have an expert working on it is really not fair. Carrie's figured this out and learned it, and it may not have been her specialty from day one, but she's clearly very well versed in this subject.
Thank you for that.
You're welcome.
Yes, I didn't know anything about falconry actually when I started. Well, very little, so I learned a lot, but I have been working on this since 2009, so it's been a while. So regarding the issues that would come before the Wildlife Resource Committee, I think sure. I'm sorry. So the issues that would come before the Wildlife Resource Committee would, the longer ones to consider would definitely be the species. I think if we were going to consider any changes to that, there's some changes in there that would require a lot of discussion with legal and law enforcement in the room. So it would be hard to run down all of the lists because we have a lengthy list of changes or suggested changes, but I think it would vary. So yes, I think you got it right.
Okay. So let me go back. I'm sorry. Let me just make one suggestion, Commissioner Hausler-Carmison. Let's discuss whether or not there's desire by the commission to go back and do the federal regs, so we can either do that or dispense with that, because I think that affects whether we talk about any other details.
Yeah. Go back and do it.
And look at adopting the federal regulations. I'd be curious if anybody feels strongly that we should do that. Please.
I think you've all gotten to know me. I want to bring everyone together, and I really appreciate solutions and problem solving. And I really appreciate Carrie's work and the department's work, and it sounds like there's been a lot of interaction with stakeholders already. But it sounds like we have a ways to go yet. So is it possible to do it in the WRC, or should it be a subgroup of the WRC? And I, for one, would like to see the differences, the main differences between the federal regs and the state regs as well. So I think it would be time well spent to go a little bit further before the commission makes a decision, to have more information come back. That's what I would like to see. And I really appreciate everyone's work, the Falconers as well as the departments, and I think this is what we're here for, is to try and help solve problems and bring people together. So I don't know if the department has the staff or the time, or how Aaron feels at WRC. I'd like to hear from them.
Commissioner Williams, please. Yeah. I mean, it seems to me, I think we are sort of dealing with two issues here. One is there is concern, if I'm not mistaken, that in 2013, when we adopted these regulations, we did not follow the federal regulations. Is that right?
So, no, I think that there was some cleanup language so that the Falconers requested some language we just didn't have time to get to because of the federal regulation deadline of January 1st.
Okay.
But George Allen did review that and he approved that package. So George Allen is the one who reviews all of the state's falconry regulations and determines whether they meet federal regulations or not. And he approved those regulations. So
Okay.
it wasn't that our regulations did not meet federal regulations. Otherwise, we wouldn't have a falconry
So they
program.
did at the time. Federal regulations changed, and now the request is to basically conform this to.
No, they
federal-
didn't change. They're just asking for what they asked for in 2013.
Yes.
Okay,
That
so I am
the
saying the same thing.
The federal regulations be adopted
Let me
as
clarify.
they are. Yeah.
Right. So, I mean, for example, this issue about the unannounced visits, that's existing language.
That's currently
not
in our
new,
regulation.
newly being proposed today. That is existing language. There's no change to the current regulation that's being proposed.
Correct.
Right? Except that when we adopted it, whenever it was, I don't know if that language was adopted in 2013, it departed from what the federal regulation provided, as we
Yes.
heard today, right? So I guess what I'm saying is, so we are working off existing state of California regulations that we are making cleanup changes to. That's one issue. And then there are a whole host of other issues where we are inconsistent with the federal regulations, or not inconsistent, or in a violative way. We've gone beyond the federal regulations. I guess that's a better way to put it. So we really have sort of two issues here. And I guess I agree with Commissioner Sklar, President Sklar, that the change to the unannounced visits, to the degree that we can clean that up today, should be cleaned up. As a lawyer, and you were doing a good job of being one earlier when you explained it, that troubles me too, that we have that sort of issue that needs to be addressed. But you know, as a chair and as a member of the WRC, I would like for the WRC to take on these larger issues that need to be dealt with in terms of looking at what we have adopted versus what the feds have adopted. So I would be prepared to support going forward with noticing this with some changes. That I know there may be other changes, but leaving to a larger discussion and putting on a as quickly as we can track to really dig in and discuss these differences and with the goal towards trying to resolve these issues, because I'm certainly quite persuaded when the regulated community comes in pretty much unanimously saying we've got a problem, and I think it's worth us taking some time to figure out how to address those.
I entirely agree, and I guess I would say that while it's never our obligation to follow what a previous commission has done, if it's a regulation or a code section we can change, we can do whatever we believe is right. A long time ago, it was decided by this commission that we would not adopt the federal regulations as is, that we would make our own regulations that conformed in some ways and went further in others. So I think it's going backwards through that. I think it will be a very long process, and we can fix most of what the problems exist, or again, the Falconers may not be happy with everything we do, but we can address the questions that they have on every issue through the WRC. And so I want to talk about two, if that's where we want to go, adopting these
President Sklar, if I may, I just want to remind you, this is a notice hearing,
Right.
so we still have 3 meetings, and we would adopt in October.
Okay, I thought it was just, I see it, yep.
We don't have to adopt today.
Right, I was looking that it was, I thought we were one ahead of it. So, which gives us plenty of time to make these changes, review them again at our August meeting, and then adopt in October if we want to do that. So I want to talk about 2 other issues. So my suggestion is that we remember that we passed a set of regulations. This is a cleanup of those regulations based on a lot of discussion, and we're going to have a phase 2 cleanup as well that would be at the WRC, and we will try to do in a timely basis. Some of the issues may take quite a while if they require environmental review. 2 other things I'd like. Glenn, let me finish up here. In general, we don't allow further debate, but as a representative of the group, I will let you come up in just a second, Glenn. 2 other issues that I think we can clean up now that I think are relatively important is, one is on the documents that a falconer must carry with him in the field. I'd like us to be more specific about that and not make it because the way it's written now, it could be a stack of documents, 7 inches thick, and if you're a falconer out walking 10 miles through the desert, you should be able to, a hunter carries a piece of paper this big. We ought to narrow what those documents are and be more specific about what they are to make it reasonable for what those documents have to be in the field. Clearly at home there's all kinds of other files that inspection can be required, but I think we need, it's just not very clear what those are, and so it could be interpreted as very broad. Please, Carrie.
To that point, in the regulations, there are various things where they would need, like for instance, written permission from a landowner, or permission from a rehab facility to fly a bird for rehabilitation purposes and assisting with rehabilitation. So those types of things that are already noted within the regulation that they would need to carry with them. So instead of listing all of those things up front, that's...
My only concern is that, again, a hunting license, there's a stamp on it for ducks, there's a stamp on it for upland games. It's still a little tiny piece of paper. Again, I've done some reading about what it actually is to go out and capture a bird. You can spend, you can do a lot more walking than for duck or for deer. I just don't want to see somebody told they've got to carry a stack of papers this thick. And so all I'm asking is that you review it, talk to the falconers about how to come up with a clear, so they know exactly what they've got to have and that it's a reasonable packet. Please.
Yeah, Mr. President, I just have just a comment. Maybe I just throw this out there for staff to look at also. I mean, we heard yesterday about the great use of technology, and now it seems to me with everybody carrying cell phones and that kind of modern equipment, it seems like you could have a good application of what they would need with them at all times, maybe through a mobile device, and also maybe using texting to tell people they're going to these officers will arrive at a certain time. I don't know how much time they need, but I'm just thinking out loud here that perhaps use of modern technology could apply very well in this case, and some of the requirements for inspections, things like that.
That's an excellent point, Commissioner Silva. And in fact, theoretically, the department has a record of all these documents already. And so if there can just be an instant check to their file, that may not be a feasible solution in the short run. But let's just look at this issue and look at ways, exactly as Commissioner Silva said, to look at technology and just common sense. So please come back to us with some ideas on this for our next meeting. And then the final issue that I'd like us to look at in this round is the revocation and punishment. Generally, in punishments that we deal with for license violations, there's various types of violations, and each one of them has a different degree of violation, therefore a different degree of punishment. If there's clear severe abuse of a bird, that may require immediate revocation. That may not be the same thing as not having a certain level of cleanliness in the pen at the moment of that inspection, because you don't clean the aviary every minute of every day. So I think there should be some look at severity of a violation and versus the immediate revocation, because I think that it is true that most other of our licensing revocations involve a whole bunch of different levels and steps and that sort of thing. Great time to have you speak up, David. Chief Bass.
President Sklar, thanks. David Bass, Law Enforcement. So that provision is a may, not a shall. It's based on an individual occurrence of a violation, and it's not an automatic where we would automatically take away someone's privilege, same as we do not for other violations, right? There's still due process. So that provision is afforded to the falconry community the same as it is the others. And I heard a little bit through public comment, so I want to clear it up. There are instances where we do things to afford take action against people's rights. If they have specific violations relative to big game take, we take away their privileges to hunt for possibly a year based on a specific violation. So there is precedent for that where we do it for protection of the species.
No, absolutely, and we take away commercial fishing licenses. But it just I just had some empathy with the language is pretty simple and pretty brief, and I think maybe I wasn't looking at all of it, but just it's another thing to take a look at. We have time to do this. Just take a look at whether or not there might be some ways to be more explicit about the fact that the severity of the violation affects whether or not an immediate revocation. Because I could conceive in situations where birds can be taken away at that moment, and there are instances where we take away people's firearms if under certain circumstances right away. It could be similar, but it ought to be spelled out a little bit about what type of violations involve that immediate revocation.
Duly noted.
Great, thank you.
President Sklar.
Commissioner Stafford first, please.
I'd like to just perhaps frame up a couple issues. I think going back to one of the key foundations of why a lot of the recommendations were rejected is that this is a cleanup package limited within the scope of the CEQA document for this section. That was a primary premise for a lot of the rejections. Second fact is, first, thank you for the assistance and training that you have voluntarily provided to our staff and officers to help enable the understanding of the sport you so dearly are passionate about. That's highly appreciated. We thank you. Dealing with how do we move forward? This is a notice hearing. I think that the language tweaks that would be developed over the next couple of meetings for final adoption, entirely doable. The bigger, broader issues, I thank you for articulating whether they're simple or complex and how big of a change would be needed. I understand the frustration with the process that was stated, and I think the department staff have really tried hard to meet. We had a lot of lessons learned about the Fed package in 2013, providing clear verbatim language versus concept language and then seeing something completely different in verbatim. We get that. But I would suggest rather than perhaps even before bringing it to the WRC or a sub-working group within the WRC, that we commit to meeting with the falconers offline and really kind of establish, a step-down, prioritized list of actions. What is the most important issue that needs to be dealt with in their mind quickly, and versus this is not so important, we can table it for a while, and then we can begin to understand clearly this is going to require a major effort, or this is a fairly simple approach. That's my suggestion, and I think if we weren't willing to try to work through this, I don't think we would have had the number of meetings that we've had. And we're continuing to try to improve our processes, and that's my suggestion. And establish a list, prioritize it, identify these can be done in these sort of time frames, and then work through that list so that we're not just hanging out here going, well, when are we going to get to this one?
Stafford, I would suggest two things. One, I think it's a great suggestion. One nuance is that I think we'd assign it to the WRC officially at probably our final decision, or probably even our adoption meeting as the last thing we do. And so it'll be in the WRC's court, but that WRC can ask for that process to occur that you've described before they actually take it up at a meeting.
Fair point.
I think that's right, but I'm not sure we can't do it on a more parallel track, Aaron, and correct me if I'm wrong, where, I mean, it would be at our next commission meeting that we would adopt referral of items to the WRC for its next meeting. So
President Sklar, if I could speak to that.
Yeah.
I'm sorry, the speaker's behind me, like I can't tell who's speaking. I don't know which side you're coming from, so I'm looking around.
Aaron's voice just got much deeper. There's a difficulty with that, and I would strongly suggest not to do it in parallel because, so this is a 3-meeting process. Once you go to notice, there is the administrative record that has to be maintained essentially by staff as far as what is going to be in the administrative record for this regulatory action. And so to try to refer amendments to the same code section to WRC in parallel would
right. So here's I got to
muddy the administrative record.
I appreciate Commissioner Williams' desire to keep this thing moving. It's been going on for a long time, but I think we can split it maybe in half a little bit here. If we can get ready so that at the October adoption meeting we're ready to go. We know what isn't included in the as changes, what's still outstanding. We can move it so that by your first meeting in 17, you can talk about it, and hopefully in the intervening time, because it's quite a bit of time between October and that next WRC meeting, the staff, the department can work on these issues with the community. Is that?
And then I wanted to address 2 other points. Commissioner Hassler-Karmazin, you requested the comparison, the Fed versus state, and Kerry informed me that information was provided in the 2013 package. So it is already in the record, and we can call out that specific item to provide to you. The final thing, to address the electronic capabilities and new technologies, I think we're all in for that. It's a matter of how we do it. We're looking at opportunities for that across multiple licensing fronts. As I say, my common sense thing says, I can buy a car on my cell phone. Why can't I have a fishing license validated on my cell phone using all the technology we got? And Chief Bess and I and Chuck and others in the department, we're all in to try to figure out how to do that. So I think it's in the future, just don't know when and how rapidly. The last thing is, I don't want to put at risk the administrative record. So following the guidance of council, I want to make sure that if we do hold discussions between now and adoption, that doesn't put the administrative record at risk if we hold sidebar discussions with the group.
I don't see anything that department having discussions offline would somehow need to be integrated into the administrative record of a commission regulatory action. So,
okay. Great, thank you.
Less lawyerly way of saying I don't see it be a problem.
While we got you on the microphone, let me ask you a procedural question here. With the 3 changes I suggested, can we go to notice and have those changes worked on before the next meeting, or do we have to renotice after those changes are actually figured out?
If the commission directs that we go to notice, basically consistent with the staff recommendation, but has some very discrete edits to that language, we could go to notice with that. We wouldn't have to go to notice with what was.
But I only have. There's 2 issues that I asked for revisions of, but I don't have specific suggestions on it today. So maybe we're pushing this back another month if we have to. If the changes come to us for a notice meeting in August. Is that correct? Mm-hmm. That feels like it. On the 2 issues of the documentation and the revocation, as clarifications on those are going to require renoticing, aren't they?
And I'm looking at staff that's quizzical. So if you're proposing that we go to notice.
With those
I'm not
changes.
sure.
My question is, can we go to notice today with the specific changes on inspections and the general suggestions on the documentation you have to carry with you and the clarification on revocation and degrees of the violation those are general comments, not specific.
Can I just for
Please.
clarification, I'm not sure I would know what I'm voting on with respect to the latter, so I would like to see that before I would vote on that.
Okay, perfect.
For notice, so I mean, if it means bringing this back at our next meeting with that language incorporated for notice, so essentially postponing this, and I had one more when we have a chance to get to it.
If I could respond to it though, so we do need to have proposed regulatory text in the notice. Right. So if you had an idea that staff that was fleshed out enough that staff could put that down to regulatory text, we could do that. Alternatively, you could authorize staff to go to notice without embodying that, and either in the discussion phase or at the adoption phase, you could address that with something more concrete, and it could, depending on how far off track you went with the current proposal, it could only be a 15-day notice.
Okay,
that
great. That answers
notice.
my question.
Yeah.
Okay, great. So go ahead, Commissioner Williams, with your other point. Then.
Yeah, and this is just really just maybe a clarification. It may not be a suggested language change, but there was one person who presented who mentioned the issue of unauthorized take, that the licensee has to ensure that the falconry activities do not result in unauthorized take. And then it was just sort of left at that. And I just wanted to just clarify my reading of the proposed language, which is that the requirement is actually that they ensure to the extent possible that the activities do not result in unauthorized take. And then it actually does specify what happens if there is an unauthorized take, if there's either an injury or a death that results, what action has to be taken. So it would not be a violation of the regulation if an unauthorized take were to occur. The violation would come if they don't follow the procedures that have to happen in the instance of an unauthorized
Yeah, so that's that section of the regulations is broken into two. So there's the non-T&E section, which talks about what they do if an inadvertent take happens and if it's injured or if it's killed, right. and that. And then there's the section following that about T&E species, which I believe they may have been referring to is the incidental take of T&E species.
Okay.
So I don't have the language in front of me. I apologize, but of the proposed regulations. So on the T&E aspect of it, it's basically they're supposed to perform falconry activities to avoid take of T&E species. So we don't go into the details of what happens if something does happen, because then it's it's a violation at that point of taking of a T&E species without permits and all of that. So it's really a question that we'd really have to address with legal, the T&E aspect, not the non-T&E aspect. Yeah.
Okay.
I believe the comment was referring to the T&E aspect.
Okay, well thank you for that clarification, and I would like to see that, because you can't avoid all, I mean, it's impossible to say that I'm going to go out there and do something and I mean, I don't know enough about, frankly, to know what we're asking them to guarantee, essentially. I don't know that you can ask somebody to guarantee that something bad is not going to happen. It's what was their intent? Were they responsible? Were they negligent? So I think it requires a little bit of thought. And again, it goes back to the sort of cut and dried, violation and how we deal with that.
Okay, just need some clarification on that. Commissioner Hosser-Carmison.
I just want to be clear. I really like Stafford's recommendation to work with the falconers and establish a list, prioritize and identify the issues. And I don't think, and I may be missing something, we're not really in a rush or under a strict timeline to do this. So as Dr. Schumann said yesterday on something else, why not take the time and get it right? And to, what happens in that interaction between the stakeholders and the department is amazing, because If they come to the table in a spirit of working things out, then it's going to come in the text, and the language is going to be clear, and it's going to be, our jobs are going to be a lot easier. So I would just recommend not rushing and adopting or going to notice on certain things, but doing it all together.
I'm going to disagree in that there's been a huge amount of work to clean up all kinds of stuff that isn't controversial. And since we're pretty close to getting that done, I think we can get that done. It doesn't take away, it doesn't stop us from doing any of the other things. It allows us to do the things we agree upon now. And so I think there's some efficiency that doesn't have any harm by completing this package, making the big changes we can, and immediately getting into the process of cleaning up the rest. I think the result is will be the same in the end, but it will be done in 2 phases and faster that way. Because there's so much in here that isn't controversial. It really is cleanup that we are doing because we were in such a rush the first time to get it done.
It just appears to me that there's a lot of different opinion on that. And I think being clear as to what isn't controversial and what is controversial is kind of important as well.
I think a perfect time to have, Glenn, do you have a few things you wanted to say? Or you seemed to want to speak before, and I'm happy to let you make a few comments because maybe...
Thank you. We appreciate the deliberation and discussion. I would like to ask Chief Best to address just one thing. While we're all in the room, it'd save some heartburn later, I think, and it's in regard to inspections. Speaking for... did I say I'm Glenn Stewart?
Can you say your name for the record, please? Thank you.
Yeah. Glenn Stewart. I'm the president of the California Hawking Club. And speaking at least for the board of directors of the California Hawking Club, in regard to inspections, Chief Best, you can come to any of our homes anytime and inspect our birds in our facilities. A part of that inspection involves reading the very tiny little numbers that are on the bands that are on our birds. That requires handling the birds. That's why it's important to us to be present. Come by to do a compliance inspection anytime. We want to be there. When you have a suspicion about a person, that's kind of a different story. I'm thinking you'll probably get a search warrant if you suspect somebody's endangering the life of the birds. And so I just wonder if you would be comfortable with the "you must be present" language for 99% of inspections, except for when you have a suspicion about a person.
So relative to the notice for inspections, I have no problem with our officers being, making clarifying language where they make a reasonable attempt to contact someone, right? And working with the falconer to be able to be there at that time. What I don't want to do is to create a scenario where someone, and of course, like many enforcement actions, we're dealing with the 1/10 of 1% of that person, of that party in that activity. I don't want to create a blanket scenario where someone could just evade a law enforcement officer, make themselves not available ever, and then we lose the teeth of the enforcement. But I have no problem as we move forward through this process putting in clarifying language that would say we would make a reasonable attempt to contact the falconer to be there at the time of the inspection.
Right, and that's the language I'm proposing, Glenn. Yeah. So let me...
I get the "you must be present" from the federal language. That's where I take it from. So okay. I appreciate your time today.
Thank President you. Sklar, if I may, too. I want to piggyback on Stafford's comments because Mr. Stewart's, a valued and respected partner to the department and to the division. I just want to extend my thanks as well as Chief of Enforcement to many of the people that got up and spoke today about their efforts to try and help train our wardens to this unique sport. It is unique. There's a lot of nuance to it. And I just want to applaud the efforts of the falconry community to try to engage with us, to try to train our wardens to be better engaged with falconry when we come out and do these inspections. So thank you for doing that. And I look forward to continuing that as well.
Deputy Director Ashcraft.
So one path forward could be that the commission could provide direction on the specific changes they would like to see considered and have the department draft that language and come back to reconsider going to notice at your August meeting.
Okay, thank you. Commissioner Williams, you have another comment?
Yeah, I do. So I did find the threatened and endangered species provision. That it's actually right after the other one, so it wasn't that hard. But I am a bit even more concerned when I read it, because whereas the other provision, as it relates to unauthorized take, includes the phrase "to the extent possible," that language is absent when it comes to the threatened and endangered species. And I should also say that it says that that the license shall ensure that the activities do not cause take of state or federally threatened or endangered or fully protected wildlife. Then it says, for example, by avoiding flying a raptor in the vicinity of a listed species. And common sense tells me I don't know how you can comply with that. How would you know that a threatened or endangered species was in the vicinity unless, you know, I don't know, maybe you can answer that question. How would someone know that that on a very large list of threatened, endangered, and fully protected wildlife in a particular geographic area is not present? So I would suggest, I'd like to hear the answer to that, but as a drafting change, I would suggest that at a minimum we add the phrase "to the extent possible" in that provision.
Okay, while they're discussing it, I'd like to say two things and then offer a path forward. First of all, you know, this is both an incredibly unique and amazing and near an ancient activity. It's a very small group of people who are engaged in it. The department has worked really hard, in spite of the fact that they have an obligation to do work for all 35 million Californians, to focus on this and try to do their best. And so I want to applaud them for that. I want to applaud the community of falconers for working with them. And this process is clearly going to go on in several stages. My suggestion is that we ask the staff of the department and our staff to work over the next 2 months with the community on these 4 issues that we've outlined. The one that Commissioner Williams identified and the 3 that I have, the inspections, documentation carrying, and violation compliance. Come back to us for a noticing hearing in August with those suggested changes to us for discussion and possible adoption of a publication of notice, or authorization of publication of notice, and that we then complete that process, having spent some time in discussion before we go to notice on those issues, and then immediately upon adoption, hopefully in December, ask the WRC and staff to go through a process that first involves a stakeholder department effort, which will then come to the WRC and finally to the commission sometime next year. That's my suggestion. It's not a motion, because we don't have to make a motion on that if everybody's in agreement with that as a way forward.
So,
does anybody disagree?
President Sklar?
Please.
I'm sorry, we were consulting.
Yep, please.
Just so I can be clear in my mind's eye, you would be asking the department to work with commission staff, do the fine-tuning of the language regarding the change from premises to facility, fine-tuning of the language per Chief Bess's articulation of the concerns regarding reasonable attempt to contact the permittee. Correct. And then to Commissioner Williams' concern under the section related to the take of endangered species, I think that will require some looking at by the department. And so in toto, I think that it might be best, rather than trying to do this on the fly, looking at it and maybe crafting some language and going to notice that may not be right. I think in order to be comfortable, we would say bring the language to the August meeting
Yeah,
that
that was my
has-
motion. That was effectively my motion.
Okay,
I would
so-
add two things, though. There's two other issues. There's the issue of the documentation required in the field, and the issue of revocation and of looking at that whole language about when revocation happens immediately. And again, there's got to be discretion in the warden's hands. And I've observed in my year here that wardens use their discretion incredibly wisely. They know the difference between a falconer who's made a minor violation or a hunter who's made a minor violation and a hunter who's really doing something outrageous. But we need to clarify that language a bit anyway. So it's those four
So,
issues, and you come back in August.
I have, then that would be 5. So 2 that we think we've got fairly close. 2, revocation and documentation in the field. And then the 5th one that is unclear is the TACA and ensuring to the greatest extent possible the threatened and endangered species thing. So
That's correct. It is 5.
We'll work on those 5 in conjunction with commission staff, and that's what we would bring to the August meeting with a full-on commitment to work with the falconers regarding the whole host of other issues, developing a prioritized list to be then brought to the WRC and fleshed out sometime in December. Is that capture where we're at?
Let me. The only correction is that the WRC would probably wouldn't. When would that next meeting be? It would probably be in
January?
January. Yeah. So the commission would officially ask the WRC to take that on for their January meeting in December.
Okay. I think that we can do that in terms of our commitment, and I would ask the falconers, let's work together. I know this has been a long process, and I know there's frustration. I know there's extreme anger, but I think we're trying to work through a very complex issue.
That's great. Thank you, Stafford. I think that's a good way forward. Commissioner Williams?
No, I was just wanted to finish by complimenting the department staff for your extraordinary efforts on this. The fact that we have these questions that come out in a public discussion is a healthy thing. It's a good thing. It's not in any way a criticism of the work product. You've done an extraordinary job, and we really appreciate it. And thank you for getting us this far.
Okay, with that, we're going to